and Royal Borough of Kingston upon Thames.
Mr. Scrunny.
May it please you, my lord, my lady, I represent the appellant, the Royal Borough of Kingston upon Thames in this matter. I lead Miss Ostler, my lone friend Miss Ostler, and Mr. Marshall Williams represents the respondent, Miss Baptie. They were the counsel in the court below.
Yes.
In relation to a timetable, I'm sorry we haven't produced a timetable. That is my fault. I take responsibility for that. I've discussed that with Mr. Marshall Williams outside court this morning. I anticipate being not more than 2 hours. He anticipates being not more than an hour and a half. There's a time estimate of 4 hours. That would leave us 30 minutes of the 4 hours, which we would then split because there are respondents' grounds, 15 minutes each. I don't anticipate, in fact, it will take that long.
But we're clearly going to deal with this within the time estimate, so we're not concerned about that.
My lord, thank you.
Yes.
My lord, there are 4 grounds of appeal. They appear in your core bundle at tab 3. And they are that the learned judge erred in law by interfering with the multifactorial assessment of Miss Baptie's reasonable living expenses which the reviewer had carried out. That ground, of course, anticipates what I will take you to in due course, was said in the case of Patel and the London Borough of Hackney. The second ground of appeal is that the learned judge erred in law by finding that the reviewer's reliance on the Association of Housing Advice Services guidance, and that's given its an acronym AHAS, as evidence of the minimum required to meet the basic essentials of life, had the effect that the assessment of Miss Baptie's reasonable living expenses was subjective and not objective. And in relation to that ground, we will have to consider what Lord Carnwath said about subjective and objective approaches to affordability assessments in the Samuels and Birmingham City Council case. The third ground of appeal, my lord, my lady, is the judge erred in law in finding that the reviewer was required to have regard to the benefit ceiling as a sanity check. And the last and final ground of appeal is that the judge erred in law in varying the council's review decision from one that Miss Baptie was intentionally homeless to one that she was not intentionally homeless, and that was in excess of his powers. The respondent's grounds for upholding His Honour Judge Hellman's order appear at tab 6 at pages 51 and 52. Tab 6 includes both the respondent's notice and the grounds. And really they correspond to a certain extent, the grounds of appeal. The first respondent ground for upholding His Honour Judge Hellman's order is, in assessing Miss Baptie's reasonable living expenses, the local authority should have had regard to the current tariffs of welfare benefits for Miss Baptie and her children prior to reduction in payment due to the benefit cap, as objective guidance of reasonable living expenses. The local authority's failure to do so was a misdirection and failure to follow the approach in, and again we come back to the Samuels and Birmingham City Council decision of the Supreme Court, my lords, my lady. The second respondent's ground for upholding His Honour Judge Hellman's order is that the AHAS guidance was not objective guidance of reasonable living expenses, and the local authority misdirected itself and relied on an irrelevant consideration insofar as it relied on that guidance at all. And the third ground for upholding His Honour Judge Hellman's order is that if and to the extent that the judge did not so find, there is no real prospect of the local authority acting rationally, finding that the accommodation, which was at 176 Leatherhead Road, was affordable, so that the decision should be varied to one that Miss Baptie did not become homeless intentionally. In the appellant's replacement skirting argument, which is at tab 4, my lord, my lady, the council deals with grounds 2 and 3 of its appeal and Miss Baptie's grounds 1 and 2 on the basis that they turn on the correct approach to assessment of an applicant's reasonable living expenses. I'll just take you to paragraph 75 of that skeleton argument, if I may. Reading this this week in preparation, I noticed that the last paragraph perhaps is less coherent than one would have hoped. It says, it also follows that just because an applicant's expenditure on basic essentials is less than the amount of benefits to which they are entitled, that their expenditure must be reasonable. What Miss Ostler and I were trying to say was that just because an applicant's expenditure on essentials is below the benefit cap, that does not mean that their expenditure is ipso facto reasonable. People may be able to live on an income that is below the benefit cap.
Yes, all right. Well, I read that 3 times without coming to any conclusions. So can we fairly much ignore that, because this is it's all by the by, isn't it? For the main thrust of your argument. Anyhow, what's your roadmap? How you?
Certainly. So what I was going to do is take you through the review decision, if I may.
Yes. Well, I think you've done that quite extensively in your skeleton argument, haven't you? But by all means, take us to it.
Well, there's one aspect, I suppose, in which I have to take you to it, which is that the reviewer did not apply the benefit cap. So she had a wrong figure for Miss Baptie's benefits income.
At the earlier dates?
At the later date.
Right, at the later date. Right.
Yes. So I concede that the figure given or set out by His Honour Judge Hellman, tab 9, paragraph 14, on page 72 of the core bundle, my lords, my lady.
Just a moment.
Certainly.
So the concession relates to the judge's decision, paragraph
14.
40.
14.
14. Thank you. Give me a moment. Yes.
So what are from April 2013, after the benefit cap came into force, Miss Baptie's income on the application of the benefit cap was £26,000 per annum, or £2,166.67 per annum. And then when the benefit cap was...
yes, okay, the figures are there. So
the figures are there.
That's correct.
They are correct figures.
Yes. Right, so you want to take us to what the reviewer said about that?
I will. If you turn to tab 14, the reviewer deals with income, my lords, my lady, at paragraphs 17 to 21. And you'll see there are 3 tables dealing with different periods. The third table...
Sorry, give me the page again, would you?
I will, certainly. I'm not sure I gave it to you the first page, I apologise. Page 125 and 126. My lord.
Yes.
Right, so there are 2 snapshots in time. The first 2013 and the second 2017, but two versions of
That's
2017.
Right.
Yes?
Yes.
Yes. And the emphasis you're placing is on the first of these tables?
My lord, it's the last 2, because if you look at the very last one, you'll see that the figure that the reviewing officer found for income at the end of the period of Miss Baptie's occupation of 176 Leatherhead Road was £1,976.29, which is £60 odd more than, that's per calendar month, my lord.
It was 1916 was the judge's figure.
That's right.
Right, so there's a £60 discrepancy.
That's right.
Right, so are we concerned with the calculation of 3,200 for the...
Not for these purposes, my lord. No.
Right, so that's historic, is it?
That's historic, my lord.
Right.
If you turn over to page 130 in the core bundle, my lords, my lady, you'll see here that there's a table starting at the bottom of page 130 in which the review officer summarises her findings on reasonable expenses. So that's on page 130, at the bottom of page 130 over to page 131, my lords, my lady.
Yes.
And you'll see she came to including housing costs, so rent. She came to £1,903.79. So less than
both of the previous figures.
Yes. And
Right, so you say that the £60 discrepancy is immaterial.
as did His Honour Judge Hellman, yes.
Is there any other concession as to the reasoning in the review?
My Lord, no.
Thank you.
So, my Lord, if we go back to the review decision, the reviewer's analysis of living expenses starts on page 127, my Lords, my Lady, at paragraph 22.
Yes, but I mean, before we go through these, what's the point? I mean, the reviewer went through all of these in considerable detail.
She did.
Right. So what is the?
So the point
we
about
don't
this
need
is,
the details until we know what the point is.
my Lord, the point is that it's said that the reliance on the AHAS guidance
Yes.
cannot be objective.
Yes. So that doesn't, as it were, depend upon the
reviewer's
detail
analysis
of
of
it, but whether it's appropriate to refer to that guidance at all.
My Lord, yes. But you'll see that what is being suggested is that the reviewer refer to other sources of objective guidance, of what is said to be objective guidance. And at paragraphs 22 and 23, you'll see that she discusses why she has in some cases and hasn't
Yes.
in other cases.
Yes. Well, we've read all that, but the debate on this appeal appears to be whether this was, as I think the respondent's notice puts it, and the judge found, forbidden ground.
My Lord, yes.
The AHAS
Yes.
document.
Well, if I deal with it in this way, then, my Lord, the judge finds that it was forbidden ground because he appears to have taken the view that the objective approach prescribed by Lord Carnwath in Samuels and Birmingham means that you have to take the average. So he equates objective with average.
Yeah, I read him as saying, as well as other things, that AHAS was irrelevant because it was aimed at the wrong target.
Yes. So his judgment is in tab 9 of the core bundle, my Lords, my Lady, and his analysis of the AHAS guidance starts at paragraph 31 at the bottom of page 75. Can I leave you, my Lords, my Ladies, to read paragraphs 31 to 37, and then I'd like
Yes,
to
well,
pick up on...
we read those.
You've read that. So paragraph 38, my Lord, His Honour Judge Hellman says, however, the AHAS guidance does not give the average cost of food and other items. It gives what AHAS describes as reasonable minimum costs.
And you say that's exactly what should be being
Absolutely.
looked for. Okay.
Yeah.
Well, that's the point.
That's the point. And that point, my Lord, is derived from the London Borough of Hackney and Patel case.
Right. Well, just to put the chronology in order.
He decided this case before Patel and Hackney was
Yes.
handed down.
The judgment here is 7th of June. Patel was handed down on the 21st of June.
That's right.
And Paley was on the 4th of February of this year.
That's right, my Lord, yes.
So, I mean, since if you want to give us a reference to Patel,
I will.
as I know you do, but we don't have to reread it.
No. So, my Lord, it's at tab 34 in the authorities bundle.
That's paragraph 32.
The paragraph that's, yes, is relevant is paragraph 32.
All right. Well, we'll obviously hear Mr. Marshall Williams about that.
I anticipate that there may be some criticism of the AHAS guidance on the basis that it's prepared by officers of local authorities. So it might be said, well, it's not objective because it's prepared by the people who are effectively making decisions in this regard.
Yes, but that's not what Lord Carnworth meant by objective. I don't think anybody's suggesting that objective means that it has to be produced by a panel of balanced experts from all parts of the field. So, I mean, for the moment, we understand your point is that it is an external source of information to which your reviewers are your independent reviewers are entitled to refer.
My lord, yes.
I hadn't seen any criticism on those grounds, except perhaps by reference in Samuel's, but that's a different matter.
It is.
The judge didn't make that finding.
No.
And I haven't seen it in the respondent's notice.
No. Perhaps if I could just take you to the most recent set of AHA guidance, which is in the supplemental bundle at tab 8.
And that's 2019.
So there are regular updatings, and my lady, yes, that's the one which in the top is headed AHAS 2013/2017/2019. So I think previous it builds on the previous analysis.
And the reviewer used this one.
The reviewer used this one, yes.
This one, yes.
So if I could just take you in the bundle to page 107 in the supplemental bundle, my lord, my lady.
Yes.
I just wanted to show you that there are tables which are based upon the costs of purchasing food. So one of the conclusions is in relation to how much it might cost to prepare meals.
Yes.
And this isn't based on figures plucked out of the air. It's based on analysis of the cost of goods. And you'll see in the bottom right-hand corner, or not in the bottom half of page 108, there's a 2019 update. And then over the page at page 109, you'll see that there are meals set out to support the proposition.
Yes, all right. Well, we have the picture.
I'm obliged. Well, really, in that case, that in essence is the appellant's case. But the AHAS guidance is guidance upon which an officer can rely as evidence of an objective approach. That in this case, the reviewer analysed the expenses that were being claimed on behalf of Miss Baptie. In some circumstances accepted them, and in others gave a revised figure on the basis of objective guidance that she got from the AHAS guidance, but also from Money Advice Service and the Office of National Statistics, and carefully analysed what the reasonable costs were, and came up with a figure of £1,907 odd. That would have meant that Mrs. Baptie could have afforded also to pay her rent at 176 Leatherhead Road, even after she was subject to the benefit cap.
But a peculiarity of this, it's a feature of this case, although it hasn't featured in the arguments, that there doesn't appear to be any evidence of Mrs. Baptie ever paying any rent from her own resource, or is that an incorrect assumption?
I don't think it is a correct. It can't. Sorry. When you say from her own resources,
Well, there were times when she was given discretionary payments, which may have, to some extent, been devoted to
paying rent.
To paying rent since the benefit cap.
Yes.
Then, after they stopped, there was, it would seem, no rent payment being made, despite the various measures that were being taken to secure it. Or is that an incorrect?
I don't think you should make that assumption, my lord. We don't know enough about it. What we do know from the review officer's decision is the level of rent arrears at the time that the possession order was enforced.
Right, well, I'll strike that. I'll strike that in that case.
And
But it isn't one of those cases, in a sense, where the case was presented below that I'm not intentionally homeless. I've been making these payments, I've been making those payments, but I've still been falling short because my budget wouldn't permit it. That was not the nature of the discourse backwards and forwards.
no, that was not the nature of the discourse.
The nature of the discourse was, and I don't mean this facetiously, but I can't even begin to make payments with a budget of this sort. Was the argument. The whole thing was unaffordable. Any rent was unaffordable.
So, in terms of the discourse, what happens is that discourse happens on a post hoc basis after the event, after Miss Baptie has been evicted.
Yeah.
Insofar as her discourse with her landlord and with the local authority to obtain discretionary housing payments was concerned, we don't.
You're not party to that.
We're not a party to that, save that we know that she didn't attend some meetings, but had possibly been told that she wasn't likely to get any more discretionary housing payments because they are discretionary. And
right. Well, I follow that. I just wanted to air that to see whether there was anything of interest to us. There clearly isn't. And if it was, it's probably to be found somewhere in the supplementary bundles.
My lord, yes. Insofar as when the benefit. This might help, perhaps. When the benefit cap was imposed and Miss Baptie was receiving benefits that were not universal credit, so they were the benefits that existed before universal credit.
Legacy benefits.
The way in which the cap was implemented was by a reduction of her housing benefits.
Yes.
Which gives the impression that perhaps you're getting money for everything else, but she was only getting 50p per week.
But that's just the way in which it works itself
That
out.
was just the way in which it's implemented, yes.
Yeah. Well, I just wanted to understand this because we're obviously very mindful that that this appeal concerns real people and the issues that it raises concerns many people in this sort of situation. I'm just anxious to get the best picture of what actually happened in the case.
With the cost of living crisis, it's only going to get.
Well, when one looks at the AHAS 2019 figures, and there's an observation saying the prices haven't really changed at the beginning, one can only begin to wonder what the next edition is going to say.
My lord, if it helps, the discourse that happened between the local authority, between the Royal Borough of Kingston upon Thames and Miss Baptie were effectively her representations on the review.
Yes.
And they are in the supplemental bundle.
Well, I don't want to dwell into that unless you think it helps us on the issues we have to decide. All right. Now, the matters that we've been talking about really are your grounds 1 and 2, which is interference with a regular review and status of the AHAS issue. Does that take us to the third ground?
That does take us to the third ground.
To what's been described as the sanity check.
My lord, yes.
I think, speaking for myself, I've sometimes found it a little hard to keep in focus what is being meant by this at various stages of the argument, and you could help us on that.
My lord, yes. I think perhaps a starting point to explain it would be Birmingham and Samuels.
Yes, please.
So that's behind divider tab 33, I apologise, in the bundle of authorities. At the time that Samuels was decided, the 2006 Code of Guidance applied to the decision that had been made in her case. So you'll see that her case got to the Supreme Court in 2019, but the decision had been made some 5 years earlier in 2014. The Homelessness Code of Guidance...
it was 2013, wasn't it?
2013.
Paragraph 1.
I apologise. Yes.
Just before.
December 2013.
Just very end of 2013.
So if you, at that time, the Code of Guidance, which is guidance to which local authorities are obliged to have regard, but not slavishly follow. A paragraph 6, paragraph 17.40 is set out from the 2006 Code. That also appears in the bundle of authorities.
Yes, we can find it there. So
I'll give you the tab number, my lord. It's tab 11, and in the e-bundle, the relevant paragraph is at page 172.
Thank you.
Before you read it, my lords, my lady, I would just say that the previous paragraph in the 2006 Code, as is in the case in the 2018 Code, sets out Article 2 of the 1996 Homelessness Suitability of Accommodation Order, which is the one which sets up or establishes what local authorities are obliged to have regard to, and it's paragraph D of Article 2 that has his or other reasonable living expenses.
Other reasonable living expenses.
Yes. So you'll see that in paragraph 17.40 of the 2006 Code, my lords, my lady, very kindly, Lord Carmichael has italicised part of it, which said the Secretary of State recommends that if housing authorities regard accommodation as not being affordable, if the applicant will be left with a residual income which would be less than the level of income support or income-based job seekers allowance that is applicable in respect of the applicant. Of course, in Samuels, one of the arguments was about whether or not they should just have regard to income support and JSA, or whether or not all benefits, and the Supreme Court decided that it applied to all welfare benefits. But you'll see there that there was a recommendation which effectively has the effect that a reviewing officer is recommended to have a look at the level of benefits. So it's a higher standard of requirement than we'll come to in the 2018 Code. In cases where the applicant's only income is welfare benefits, then of course necessarily the reviewer knows what those benefits are because they've worked them out for the purposes of establishing income. So it's difficult to see that you would have to have a further regard to the amount of benefits, because you know the benefits because you've assessed them for the purposes of making the decision, because that is the person's only income.
Yes. Yes.
In Patel, the Code of Guidance was amended in 2018, and as someone who operates in this area, practices in this area, I can tell you that it's been further amended, the 2018 Code, on I think 22 occasions, as a result of other statutes that have been brought into effect. For example, the Domestic Violence Act. But paragraph 17.46 in the new code has remained consistent. It's set out in Patel, which is tab 34 in the authorities bundle at paragraph 11.
Yes.
And you'll see there, the fifth line starts, housing authorities may be guided by universal credit standard allowances when assessing the income that an applicant will require to meet essential needs from housing costs.
But, etc., etc.
Yes.
Yes.
The other point is that cases are meant to be assessed on a case-by-case basis. So, in some circumstances, welfare benefits may represent an income that more than meets somebody's essential needs. But in other cases, if the family have particular expenses, it may not. Going back to Samuel's and paragraph 36, my lords, my lady.
Yes.
At the bottom of the paragraph, Lord Carnworth, the last sentence says, in the absence of any other source of objective guidance on this issue, it is difficult to see by what standard that level of expenses could be regarded as other than reasonable. So he used the benefit income, welfare benefit income that Miss Samuels was entitled to of £1,349.33 and applied it to the to the expenses schedule that have been provided by Miss Samuel's solicitor of £1,234.99. And so he used as objective guidance the amount of welfare benefits. In that case, the reviewing officer's decision that was quashed is set out in paragraph 14, my lords, my lady, of the decision.
Right, just before we leave the benefit level, right, so forgive me if I misspeak, but this is not a cap case.
I don't think we know. I think there were two children. I don't think it is. No, it isn't.
I mean, just from the figures, because
No.
the idea of the cap was just in some rough or ready way apparently was to tether benefits to average
Earnings.
family income.
That's right. In relation to larger families.
Which would only kick in with
Yeah,
larger families.
that's right.
So Samuel's doesn't help us, or didn't help the reviewing officer with the question of what is the thing that you have to have regard to.
No,
where the benefit cap has in fact been applied.
that's right. It doesn't help.
Right.
But
Just a moment.
My lord, sorry.
Thank you.
If then you could turn back to paragraph 14 in Samuel's, my lord.
What would you like us to look at?
So, the reviewing officer finds that the accommodation was affordable because, and the substance of the decision is set out in the last sentence, set out from the decision letter, starting 3 lines up from the bottom. I cannot accept that there was not sufficient flexibility in your overall household income of in excess of £311 per week to meet a weekly shortfall in rent of £30.
Right, so this was a robbing Peter to pay Paul approach, was it?
Absolutely. And so the reviewing officer hadn't carried out any analysis of the expenses by reference to what would be necessary to meet.
Right, so the argument was, well, it's not much of a shortfall, you should be able to find it from somewhere.
Absolutely.
Right, and that, says Samuels, is not good.
That's the subjective approach. And the objective approach requires you to have a look at
what the figures are on both sides.
Absolutely.
And see whether they meet or not.
Absolutely. So the review decision letter itself didn't contain any objective analysis, objective guidance of what would have been reasonable expenses.
Right, so am I right to understand Samuels then as being authority for saying that you actually have to look at the actual figures and to see whether the reasonable minimum expenses fall within the income level?
I would put it slightly differently. I would say that Patel and Hackney is authority for the proposition that if somebody does do that, then their decision is unimpeachable unless there's some error of law.
Yeah.
But on facts, this wasn't a case. Samuels wasn't a case in which the officer had looked at Ahaz.
That's right. So when Lord Carnwath says there's no, in the absence of any other objective guidance, I'm going to refer to the benefits level.
Yep.
That's because the reviewing officer hasn't carried out any objective analysis of what was being asserted as income and expenditure, but just saying, you're only a little bit short. Come on, you can make up the difference.
And that is the approach that Lord Carnwath
Criticised, yes.
Criticises.
And that is what he called... his use of subjective and objective in the case is perhaps not how, as lawyers, we might often use the word subjective and objective approaches.
It's really a question of whether there's some evidence base.
Absolutely.
For that would be another way of saying objective.
That's right.
And the fact that the evidence comes from sources that may be contentious or not is something that has got to be considered on the merits of the contention.
My lord, yes.
But
Samuels is not authority for the proposition that even under the code as it then was, that you had to use the benefits as a sanity check or as a cross-check for what was reasonable expenses.
Well, presumably in relation to income, the benefits level speaks in one way or another as to whether that income is to be considered to be a guideline figure of importance. In relation to expenditures, there are a number of resources which are referred to in Samuels. One of them is Ahaz, to which decision makers might have regard.
My lord, I don't think that Ahaz is referred to in Samuels. It is referred to in Patel. If I'm wrong about that, I apologise.
No, well, I'm sure you're not.
Well, I think it is referred to in 29 and 41.
Yes.
By
recitation or reference to
it is
evidence adduced from the chief executive of shelter.
That's right.
I apologise. It wasn't relied on at all by the local authority because they hadn't carried out an.
No, but this is narrative,
yes,
really, as to the sorts of things that are out there to provide
objective guidance.
Yes, so that it isn't simply what the individual reviewing officer thinks, which might be different from the reviewing officer at the next desk.
My lord, yes.
I hadn't worked out who the interveners were in Samuels. It's a bit of a task, and I couldn't work it out. But it's not in the title of the case. Mr. Westgate, with two juniors, instructed by Freshfields, appeared for the interveners.
Instructed by Shelter, I think.
It was Shelter, was it? That's what I thought it was.
Shelter.
Were there two cases? Was it just one?
It was just one case.
Just one case.
Yeah.
DS two cases.
Yeah.
All right.
So my submission is in response to the judge's finding that the failure to refer to the benefits level, or use the benefits level as a cross-check, is supported by Samuels. He's not right about that. That's an error. Samuels doesn't say that you have to refer to the benefits check. The reason why the benefits were referred to in that case was because nothing else had been produced by the local authority as evidence.
Could you just take me back, because I'm sure you've done it already, but where in Samuels is the nearest we get to a statement about the significance of the benefit level?
Well, the judge's discussion really starts at paragraph 32, Lord Carnwath's discussion, and I think it's really in paragraph 35, perhaps.
Well, I'm just picking up earlier on 26, but there was a submission that benefits are intended to be no more than the, quote, officially prescribed subsistence level. So that the argument is being developed there. And you take us on to, I'm sorry, paragraph.
If you go to paragraph 35, there's a sentence starting 6 lines down from the top. 7 lines down, as the authorities referred to by Mr. Stark,
yes,
open brackets, paragraph 26 above, close brackets, show, benefit levels are not generally designed to provide a surplus above subsistence needs for the family. But I repeat the point that where you have a case where somebody's income is, as it was in this case, and where somebody's income is solely dependent on benefits, of course the reviewing officer knows what that income is.
Yes, so paragraph 35 and a half, as it were, which you've been showing us. If comparison with the relevant benefit levels is material, is how it's put there, and it's rather similarly guarded at the bottom of 36.
Yes.
Difficult to see how it could be regarded as other than reasonable. So your point is that it's nothing in Samuel's that creates anything approaching an iron rule that the level of benefits has got to be regarded as being the reasonable level of expenditure.
Or that it needs to be referred to as a cross-check in the review decision letter. And that was the position under the code that applied when the decision in Samuel's was made.
So it's been, the link is even less strong after the 2018 guidance.
Yes.
On the other hand, he is indicating that it was in that case and would seem from the 2006 guide to be generally a relevant consideration. Would that be fair?
I don't think it's a consideration that no authority properly directing itself would have failed to have had regard to. So that would be the test for, I don't think that his judgment can be said as supporting that proposition. So,
At the end of 35, though, at the very end, it
yeah.
said that it's at least a good starting point for assessing reasonable living expenses.
yes.
And perhaps that's a high watermark.
Yes. I mean, I just go back to what he says in paragraph 36, which is there was an absence, though, of course, in that case of any other objective guidance. So he fell back, if I can put it like that, on the level of benefits.
So again, that takes us to the door of the question of what does the benefit cap then mean, because these remarks are being made in the context of uncapped benefits, that it's said a number of times in the submissions that we've received that the government did this and the government did that. We're not concerned or interested in what government does.
No.
We're concerned and interested in what Parliament does.
Yes.
And Parliament has ordained that something that was previously calculated to be a need at a minimum level is to be suppressed.
Yes.
For wider reasons. So how does anything in Samuel's assist us in trying to interpret what to make of capped benefit levels?
So, my lord, if I can answer that question in response to the grounds for upholding the order, ground 1, in which my learned friend submits that the local authority was obliged to have regard to Miss Baptie's welfare benefits and her children prior to reduction due to the benefit cap. In my submission, that can't be right. The current level of benefits are her benefits subject to the cap.
So the consequence of the cap is that you say must be assumed to be Parliament's vision of what minimum reasonable needs are.
My lord, yes.
So if we look at the figures that have been set out in the respondent's skeleton argument for the universal credit level, which it said the reviewing officer should have taken into account, your submission is, as I understand it, those are not relevant because they're all capped.
My lord, yes.
And those are the figures at paragraph 23.
And so the reviewing officer was entitled to disregard them or not to take them into account.
My lord, yes.
And have regard to the AHAS figures as an available resource and the other figures
Yes, my lord.
of objective evidence of what minimal reasonable needs
My lord, yes.
required.
I mean, I say that there's no authority for the proposition of ground one for upholding the order that some historic benefit rate should be had regard to. I mean, the effect of that would be that anybody who is subject to the benefit cap, effectively, if they lose their accommodation as well as a non-payment of rent, will be
Unintentional.
not other than intentionally homeless. Yeah.
And your case is that it's not for individual reviewing officers to be reflecting on the rights and wrongs of the benefit cap. They're entitled to view that as being the environment in which they are, for better or worse, required to operate.
My lord, yes.
When you say they're historic figures, there'll be people who are not subject to the cap at any given time, and people who are, whose cases have to be considered.
My lord, if somebody's benefit income goes above the cap level,
Yes.
their benefit is capped.
Yes.
So the figures, the total monthly amount given by my learned friend for Miss Baptie's benefits prior to the imposition of the cap would not apply to anybody.
I'm sorry, Mr. Marley, when you say that again?
Yes.
So, you're saying if people's benefits go above the cap, then they will be capped.
Yes.
And then you said these figures wouldn't apply to anybody.
It's because, sorry, the figures set out in my learned friend's skeleton argument, paragraph 23,
Yes.
are not benefit that anybody could now receive because the figures are higher than the benefit cap. They result in a sum that is higher than the benefit cap. So it's not a question of comparing case A, which happens, with case B, which happens. It's an example of comparing case A with a wholly hypothetical set of situation which can't happen because the benefit would be higher than the benefit.
And you're going to come at some stage to what's said in Paley about this.
Well, in my submission, Paley was the decision in Paley was on the basis that the local authority had failed to take into account reasonable expenses, which Miss Paley had told them about.
Yes,
in
but
deciding that
you say was the core of the decision.
Yes.
And that then there's a paragraph which you comment upon as to its.
Well, I mean, in my submission, it wasn't part of the it wasn't not part of the ratio.
Right. Well, does that paragraph touch upon what we're talking about at the moment?
I don't think. Well, in my submission, no, it doesn't.
Right. Remind myself.
This is paragraph 76.
Thank you.
I mean, I understand that you say that's not part of the ratio of Paley, but what do you say it actually means?
Well, in my if somebody is subject to the benefit cap and the local authority has to take into account all of their income, and their income is solely from benefit, by calculating the figure to benefits to which they are entitled, they have had regard to the benefit cap.
Yes. But that's an argument really that paragraph 76 is wrong, I think.
No, sorry, it isn't an argument that 76 is wrong. Necessarily, the local authority under Article 2 of the 1996 suitability order has to take into account all of somebody's income.
Yes.
If all of somebody's income is derived solely from benefits, and they are subject to the benefit cap, the figure that the local authority has for their income is that sum. So they have necessarily had regard to their income subject to the benefit cap.
Oh, I see. I hadn't really focused on the second line here. It's having regard to the allowances when assessing the income an applicant will require. Oh well, maybe I had. I find paragraph 76 with respect quite difficult to grapple with. Your point is simply that the starting point is the income, and then the rent, and then the reasonable living expenses. And in a case where someone's on benefits only, the universal credit is taken into account at the first stage.
Yes. Save that in this case, universal credit hadn't yet applied to Miss Baptie, and she was still in receipt of the benefit.
Yeah.
You know, the benefits that
the legacy benefits.
Yeah.
It's the last sentence, isn't it, that cuts across your assertion that the capped benefit must be taken as being the reasonable minimum needs provision. That's inconsistent with the last sentence of 76.
Well, Lord, yes, but in my submission, the last sentence of paragraph 76 isn't part of the ratio in this.
No, well, let's for the moment
and what?
ignore the status of the statement.
Well, Lord, yes.
Why should the capped benefit level be treated as a reasonable minimum needs figure?
So why should it or shouldn't it?
Why should it? I mean, your assertion is it should be treated as Parliament's restatement of the minimum reasonable needs figure.
Yes.
Why should it be given that status?
Because if it isn't, then Parliament is clearly paying too little benefit for people to survive. So benefit has been calculated on the basis that a group of people who are subject to the benefit cap will not have enough money to meet their essential needs.
So it is a corollary of that a decision maker or a reviewer is obliged to consider, is obliged to adhere to that.
The corollary of that is that we go back to Article 2 of the suitability order and we say, what is all of somebody's income?
Yes.
What are their essential living needs before they pay their accommodation costs, so their rent?
Yeah.
After they've met their essential living needs, do they have enough to pay their rent?
Yes.
And that's in my submission, that's what Samuels effectively says. And Patel and Hackney supports that proposition because in that case, a careful analysis of somebody's income and expenditure was not overturned.
But it must be open, must it not, for a decision maker to say, well, yes, X is the figure that has been assigned in benefits to this family. Having looked at this family about which there's nothing special, so we're not talking about outlier cases, but just an ordinary assessment, I find that their figure of reasonable minimum expenditure is Y. Y is in excess of X.
Yes.
So that's a calculation that can be carried out.
My lord, yes. But if you have...
But the conclusion from that would be that it undermines what you just...
No, my lord, it doesn't, because people who are subject to the benefit cap may very well be unable to afford their accommodation. There may be circumstances. So in the case we're dealing with here, Mrs. Baptie had a tenancy from a housing association, so her rent was lower than the market rent.
Yes.
If she had been in accommodation where the rent was higher than the market rent, she would nonetheless have been subject to the same benefit cap, so she would have received the same money. So it's
Well, there may be individual cases in which the capped benefit doesn't provide enough to live
Absolutely.
on and pay the rent, but it doesn't mean that's the case in every.
absolutely,
circumstance.
and what a local authority is required to do is decide them on a case-by-case basis. So benefits must be benefits are calculated on various assumptions.
But what I'm trying to explore here is whether the amount of capped benefits is really likely to be a very sure guide to anything at all. That I appreciate that the decision maker may have regard to it,
My lord, yes.
but the amount of capped benefit may be of very little use at all in deciding what is a reasonable minimum.
My lord, certainly, because a family bigger than Mrs. Baptie's would presumably have greater costs but still be subject to the cap.
Yes, a family even bigger than,
Yes.
than Mrs. Baptie. But so when we go to paragraph 1746, may be guided by the standard allowances. It's just beginning to seem to me, speaking for myself, that in a case where, for reasons that seemed good to Parliament, the otherwise applicable going rate has been suppressed by the cap.
My lord, yes.
I'm finding it hard to see one gets much help as to the fact that the figure paid is anything other than the figure paid.
My lord, yes. And
I mean, it's what it is.
my lord, that's really my point. And I'm sorry to say. Once you've calculated,
But I thought you were making the greater point, which I was having difficulty with, which is that because Parliament says that capped benefits is what they're getting, that must mean that that's considered to be a reasonable minimum needs level, whereas it may be anything of the kind.
Well, my lord, I don't resile from that proposition, because the alternative is that Parliament is not providing enough benefit for people to survive. But I accept the proposition that in carrying out this affordability assessment, which is a different exercise,
You have to look at the actual.
you have to look at the actual income.
But are you pushing back against the thought that where benefit is capped, and quite severely capped as it was in this case, because there was not just, as it were, a £48, I can't remember whether this is a weekly or a.
Mrs. Samuels was required to find £34. I think.
Yes, but is that weekly or monthly?
I think that was a week.
And Miss Paley was £48,
Yes,
£46. Is that a weekly or a monthly figure?
weekly.
Right. Okay. So the figures are somewhat less than they are in this case. I mean, the effect of the benefit cap in this case was a very substantial reduction in the
My lord, yes.
figure by something in the order of pulling figures out of the air, a fifth or something of that sort of the total income.
My lord, yes.
But that in cases where the benefit cap has a marked effect on the actual received income, it might be thought that the may be guided by requirement of the code is not likely to speak very loudly in the individual case.
My lord, yes. I
just want to know the sense of that.
No, I agree with that proposition, but you can see it, and it builds in some difficulties, because you said when there's a marked reduction. Well, at what point do you decide there's a marked reduction? Now, except in this case,
The more
you might
marked
say
the
there's a
reduction
marked
is, maybe the more faintly that part of the guidance
Absolutely,
speaks.
but then the next question is, how do you assess what benefits would be for a family who are not subject to the cap?
What, because the benefits level change from time to time?
Absolutely. And so what's being suggested by my learned friend is that you have regard to a benefit level that was being paid prior to the cap. But we know, for example, that child benefit was decreased for children after the first child and has been taken away from people with incomes above a certain amount and that sort of thing. So the difficulty is that the benefit system is being varied, changed.
Well, or in fact being changed by not being uplifted over periods of several years.
My lord, yes.
So change by doing nothing.
But I agree with and accept the proposition that in circumstances where somebody is subject to a cap, their benefits to which they are entitled might not be a very good guide at all.
All right.
And that comes back to the proposition that what you have to do is carry out an analysis on a case-by-case basis.
Well, thank you for indulging me in that.
Just sorry to prolong this. The cap doesn't apply to child benefit, does it?
Can I take some instructions on that? I don't think it does, but
well, that's just a further complication because if it doesn't apply across the board, then whatever changes are made in child benefit, then that's another complication in the task of trying to say or not say that the capped benefit sets a minimum subsistence level for everyone.
my lord, yes. I'm instructed that you're right, my lord, the benefit cap does not apply to child benefit.
But what you've just said, which is where there's a cap, the benefit to which one is entitled may not be of much help, which is what I wrote down from what you just said. And anyway, you have to do this on a case-by-case basis.
My lord, yes.
Actually, dovetails with that last sentence in paragraph 76 of Paley, with which we were struggling, because there, Lady Justice King is saying there may be a cap, but it doesn't mean the local authority can simply ignore its impact in assessing the affordability of a property. So, interpreting that widely, one might say what she's saying is once there's a cap, it doesn't necessarily help you in determining the question that you're grappling with, and that's all she's saying.
My lady, yes, and I mean it may be that she's also said, or maybe that I'm regurgitating to you in a different word, rephrasing what you've just said to me. You have to consider what this person was actually receiving.
Yes.
Because we're talking about the implications of what they're actually receiving for what is reasonable.
Yes.
And that's where the link may be stronger or weaker depending upon the impact of the cap and the circumstances of the family.
My lord, yes.
Right. But my questions to you were, in a sense, designed to push back against the proposition that decision makers should feel themselves pushed to take a different standard of reasonableness because of the capped benefit level. That it seems to me, and I think Lady Justice King appears to have thought similarly, and the other members of that court, would not be right. It's not to be regarded as an iron ceiling for what is the reasonable level of need.
My lord, yes.
All right. Well, I think you and Paley appear to have met in the middle somewhat. Whether or not that was essential to the decision of the court on that time.
My lord, yes. Thank you. So the last issue really to deal with is whether or not His Honour Judge Hellman should have
ground 4
and ground 3.
Do you say he should have made if he was right on quashing, he should have asked it to be remade?
My lord, yes. If I could just quickly turn up my notes, I apologise. So, my lord, the authorities for the circumstances in which a county court on a Section 204 appeal should impose its own determination of the decision are set out in Dwayne and Tower Hamlets, which is tab 29 of the authorities bundle. It's Lord Justice May giving the decision of the court, my lord, my lady, and it's at paragraph 37. Well, it's the last sentence really of paragraph 36, and then explanation at paragraph 37. So if I'll read the test. The question for the judge was whether there was any real prospect that Tower Hamlets, acting rationally and with the benefit of further inquiry, might have been satisfied that Mr. Agee was intentionally homeless. I won't read paragraph 37 because there Lord Justice May deals with how he's come to that formulation. That formulation was approved in Slater and Lewisham with a different outcome. So paragraph 43 in Slater
Just
and Lewisham.
save me reading on. Remind me what in Dwayne was the outcome of that.
The decision was not varied.
Sorry. Just a moment.
So in the head note you'll see the circuit judge has been wrong to vary the decision to record that the appellant was owed a duty under section 1932, pausing there and interjecting. Section 193 is the duty which is what housing lawyers refer to as the main housing duty, and that's the one that is owed to secure people accommodation for the long term. Semicolon, he had not been entitled to conclude that the authority could not properly have felt obliged to make further inquiries before being satisfied that the appellant was not intentionally homeless.
Right. So, what the judge had been right to quash the decision,
He'd been,
but not right to remake it. Is that what's going on here?
yes.
Right, and you say that Slater's one in which the other conclusion was reached.
That's right. So if you turn to paragraph 43, my lord. It sets out the sentence from paragraph 36 of Lord Justice May's decision, which I've read, and then sets out paragraph 37. In this case, Miss Slater felt threatened.
What page are we on?
In the bundle,
Yes.
or of the report.
It's not numbered.
Page 689 of the report, paragraph 43.
Thank you. Yes.
In this case, the appellant, Miss Slater, had been offered accommodation within part of Tower Hamlets, and she refused this on the basis that she felt threatened, or she felt a fear of violence from her former partner, Mr. Damien Winnie.
Yep.
She provided material that indicated that he was certainly a reasonably regular visitor.
Well, we see the issue, and the answer was that the judge was within his rights to remake the decision.
My lord, yes, there's a helpful paragraphs 47 and 48 set out the material that Miss Slater had provided to the local authorities to support her fears that Mr. Damien Winnie was more likely to visit violence on her.
Right.
And then at paragraph 48, what the local authority had relied on to dismiss her fears, And at paragraph 49, there's a very helpful summary. So you can see in that case the extent to which the local authority's decision-making process was based on insufficient and, in fact, incorrect information to counter.
All right. So, in a nutshell, in the present case, if the judge had been right to find fault with the review decision, how do these principles work?
If it is right that in some way the local authority's analysis of Mrs. Baptie's income and expenditure doesn't meet the Samuels and Patel criteria, in my submission, the local authority should be given another opportunity to have another go. Because if what he said is, well, the AHAS guidance isn't objective, the local authority can have an opportunity to.
Does it rather depend upon the basis upon which the basis upon which the decision was interfered with? That in this case, the judge is to be taken as right for the purpose of our discussion in saying that the whole thing went wrong with the AHAS approach. And so you say with that sort of information, the judge can go no further than to say, well, you didn't get it right because of that. The judge can't possibly at that stage go on and know what the correct answer is if you've not been misled.
My lord, yes. And I can take you to if I take you to paragraph 41, for example, in His Honour Judge Hellman's decision, that's tab 9, page 77. One must not nitpick, but sometimes a part may illuminate the whole. The review decision stated at paragraph 25, if you choose to buy your daughter a mobile phone in 2018, that was a
yes. Now we see what's there.
So if you go found 42, irrespective of that example, and for reasons given, I find that the reviewing officer erred in law and her decision was flawed on public law grounds with respect to her assessment of what would be a reasonable level of expenditure for the appellant. So on the basis of his decisions above, his reasoning above, he goes on at paragraph 43 to say, I therefore find that the decision that the accommodation was portable was one that no reasonable authority properly directing itself could have reached.
Yes, right.
And we say he clearly exceeded his powers. There, on a further...
That's because the decision in Slater, as an example, was as it were, a one-factor issue, namely whether the presence of the former partner in the area, which was found to be the case from time to time, could ever mean it was a safe place for this applicant. Whereas this is a multifactorial question.
So when Slater was decided, when offers were made of final accommodation, they not only had to be suitable, they had to be reasonable for the applicant to accept. That requirement has been removed.
Right.
The reasonableness could relate to could turn on the applicant's own perception. So was her fear? The question was her fear a reasonable fear?
But the feature of Slater was that it was, as it were, a one issue question, which an appeal tribunal, in that case the judge, could well be expected to take a view as to whether you could whether the housing authority could ever overcome that issue.
My lord, yes, that's right.
Whereas here, if they got it wrong the first time in relation to the use of one set of guidance, then you were entitled to the chance to get it right without offending.
My lord, yes.
Right.
And also, no doubt you would say that in these circumstances, the judge had no basis on which to conclude as he did, because having struck away the use of the AHAS figures, he was just surmising what might be the case. There were no other figures which he had concluded were specifically correct, which inevitably led to a different conclusion. He was just blue sky thinking.
my lady, yes, he was, and you can see that at paragraph 40, I think. In my judgment, the reviewing officer's finding that monthly expenses of £1,901.63 were unreasonable was irrational. But he doesn't have any basis for himself coming to that view.
No grist to his mill.
My lady, yes.
Well, another analysis is that he found at least one and possibly two legal errors. One was having regard to irrelevant subjective AHAS guidance, and the other was a failure to have regard to the cap. For those reasons, quashed the particular decision, and then went on without applying the Dewey test to say in paragraph 44 that he made the decision himself without giving any reasons. That was my original response to it.
I can understand. I understand faced with people whose income is capped, so severely.
Yes.
That circuit judges are presented with difficulty.
So no, it was, you were never going to get there, so why give you the chance?
My lord, yes. So, my lord, those are my. Unless I can be of any further assistance, you've kept me down to an hour and a quarter. Thank you very much.
Thank you very much. Yes. All right. Now, Mr. Marshall Williams, are you at any disadvantage in being in the middle of the court? Would you want to come forward in order to make your submissions? Are you happy where you are?
I'm happy where I am.
Good. Thank you.
My lord, my lady, I had a roadmap going through this with the affordability in regard to benefits issue first. I can just another way of that is of more assistance, but I proposed essentially to start with the Samuel's case. I just remind you what we're dealing with here is the assessment of reasonable living expenses, specifically other reasonable living expenses except rent, because that's taken for granted under the order. And so when we were looking at Samuel's was concerned with arguments in relation to both parts of that, but I would ask to focus on how it approaches the decision in relation to the assessment of reasonable living expenses alone. The case is at tab 33, and I wanted to remind you of the argument which was actually put to the court, and therefore the court is dealing with, because that appears at paragraph 21, where it is what is put forward on Ms. Samuel's behalf is an argument that it is wrong in principle to treat non-housing benefit income as containing a surplus, which should be treated as available to make up shortfalls in housing benefits.
Just
quite specific.
Do you mind if I just read that paragraph for myself?
21.
Paragraph 21, Samuel.
Right, so that was what I've described as robbing Peter to pay Paul.
Yeah. So this is an argument that, the argument that is made is essentially that you should apply the order in a particular way. That's an argument that's failed. It is right to note that linked to that is the argument which is then set out at paragraph 22, which is a submission that and this was one that insufficient regard has been paid to the if we say the 2013 Code of Guidance, but paragraph 1740, which is the Code of Guidance in force at that point, and that properly interpreted, that guidance should be considered to apply to benefits for children. And then the paragraphs after that describe the way in which the law relating to income support has changed through the way that tax credit loans come in, and why an issue has therefore arisen as to what that paragraph of the code might be said to cover, whether it included benefits for children, which for most people, Ms. Baptie, were being received in the form of child tax credits.
I see in 24 that Child Poverty Action Group was one of the interveners.
Yes, that is what so my understanding is that the intervention was shelved from the Child Poverty Action Group, and that there's evidence from both of those they're the ones relevant for us today as the evidence from Ms. Nita's shelter. So it is to that argument that Lord Carnwath is responding at paragraph 34 on page 1240, and he refers in the first paragraph, first sentence of paragraph 34, to the dispute about the meaning of paragraph 1740 of the old code, but he makes clear those issues are not, in my view, critical to the resolution of this appeal, and instead he says, I would start from the terms of the order itself. And so my submission is the way that Samuel should be understood is as setting out a basis on which the housing authorities should assess reasonable living expenses, starting from the point of view of the order rather than the code. And I would suggest that is unsurprising because it is entirely clear when we look at paragraphs 38, 39 and 40 that Lord Carnwath had well in mind that by the point that the Supreme Court was considering this, the code had been changed, and it had been changed into the form in which you have it in front of you today. And he sets out at paragraphs 39 and 40 that the code had changed from its the first draft version of what was then 1745, which simply referred to the basic test of whether they can afford the housing costs without being deprived basic essentials such as food, clothing, heating, transport, and other essentials. And then to that had been added in the final version the reference to being guided by universal credit standard allowances. But what's so that was clearly in the mind of Lord Carnwath in giving his decision in the Samuels case, which clearly is not a case on which that version of the code directly applied. It makes sense to understand what he says in saying that the arguments about the code that did apply were not critical, as giving a decision which is wider than those circumstances. So it's in that sense, I would submit that we don't need to, it's not correct to say that simply because the code has changed, there should not be reference to the benefits available. And that is supported by the approach that he takes in paragraph 35, where
could you just sum up so that we better understand this? What is your essential submission in relation to the significance of Samuels for the decision in this case?
It is that what is the objective approach that has been the objective approach to the assessment of reasonable living expenses should be done on the basis that the
I'm just taking a note of this. The objective approach to the assessment of reasonable living expenses should be
done having regard.
Should have regard.
Yeah, to the applicable amounts of universal credit for the household concerned. As a source of objective guidance.
And by the applicable amounts, you mean, in fact, the uncapped applicable amounts?
Yes, which is what the allowances are referring to. So the allowances refer to those amounts.
But since Samuels was not a case in which a cap had applied, how do we derive that proposition from Samuels?
So where we get it from is that if we look at paragraph 35, what Lord Carnwath accepts is that the authorities show that the benefit levels which are set are not.
I'm sorry, you're reading from
paragraph 35.
At H.
As the authorities show. Yes, thank you. but why does his reference to benefit levels? Why is that to be taken to refer to uncapped benefit levels in a case where he is not speaking with regard to capped benefits?
Because both the previous guidance at 1740, they make quite different statements, but what they refer to are the allowances applicable to families. It's particularly notable in the case of the revised guidance, which is now 1746 and what is now in force, that despite the fact that this was brought in 2018, of course, a number of years after cap was introduced, there is no reference to the cap at all in that, and instead the suggestion is having reference to standard allowances without having any reference to the cap.
And we're to take the absence of a reference to the cap as an indication that is not to be had regard to.
It must be what is the reference to standard allowance is a reference to the prescribed amounts for
Regardless of the cap.
Yeah, so the regulations set out those prescribed amounts, and if which you guess the cap doesn't apply, and it is a reference to that because, as Lord Commonwealth accepts, the benefits are set at subsistence level. That is being said to be an objective guidance of what subsistence level is. What is that? Whereas the old guidance made a substantive recommendation as to the circumstances in which accommodation should be found to be unaffordable, the revised guidance is saying that regard should be had to it. That is a change, but the what they refer to in both instances are the amounts which are prescribed in respect of applicants or persons in their household.
Yes, I'm sorry. I was just reminding myself of 1746, which is where you gained the reference to universal credit standard allowances.
Yeah.
And you say that was drafted in the knowledge of the existence of the benefits cap.
Well, plainly, this is drafted in 2018.
Yes.
After, I mean, the Commonwealth makes clear that the basis for the change between the draft and final version is not known, but that is, it gives that further guidance, and that is what it refers to.
Right. Well, in the search for elephants in rooms, is there anything in the code of guidance that refers to the benefits cap?
Not that I'm aware of. I'm not aware of any sort of reference.
Just a moment. Right, well, just doing a search, comes in 2012, and there's a specific section entitled benefit cap in the 2012 legislation. And it doesn't appear in the 2018 guidance, as you
I
thought.
don't think so. My Lord, to be complete, I'm not aware of any reference.
No. What I'm saying is that my search of the guidance doesn't bears out what you say, that there doesn't appear to be anything in the guidance. So I'm bound to feel considerable sympathy for decision makers armed with guidance when no reference is made to something as prominent.
Well, my Lord, yes, but the in my submission, the reference to standard allowances for universal credit is a relatively specific thing which is known and which decision makers can refer to. But what is obviously being said, the difference between the 2006 and 13 guidance and the new version is the change from a substantive recommendation that you shouldn't find it affordable to saying you may be guided. That is a change, but it's still clearly being suggested this is relevant. Going back to what we can learn from Samuels, I would also suggest that the reason why it is relevant in terms of the assessment of why benefit levels are relevant is that it clearly clearly considered the other guidance that was available, which includes this is paragraph 29 of Samuel's case, and on page 1239, at paragraph 29, it set out very clearly that the intervention from shelter was supported by evidence from Polly Needs, the chief executive, and which complained of the lack of generally accepted guidance to assess the reasonableness of living expenses under the 1996 order. In other words, precisely the issue we're concerned with here. And it says it sets out the results of shelters inquiry, and it then looks at the evidence that talks about the absence of any transparent or evidence-based guidance for that purpose. That's the criticism made, and then we can see at F that the guidance that is being referred to is the standard financial statement, the common financial statement, and the Association of Housing Advice Services guideline figures. In other words, the figures that are in front of you today, and what is pointed out there is that none of these are in fact designed for assessing affordability under the Housing Act.
According to Miss Neat.
According to Ms. Neat, yeah, that's her evidence, and then we need to look at paragraph 41 to see what Justice Conworth made of that. And his comment on it is that evidence shows what appears to be an unfortunate lack of consistency among housing authorities in the treatment of affordability. That's not dealing with guidance, but the next part is, and a shortage of reliable, objective guidance on reasonable levels of living expenditure. So that clearly is his comment on what the evidence shows. And then, to understand it further, one needs to look at the basis of the decision, because the decision referred to at paragraph 36 to an absence of any other source of objective guidance on this issue as in reasonable living expenses apart from welfare benefits. And then at paragraph 37, when considering the disposal of the appeal, although all this is sought was a quashing by the Samuels Council, but what Lord Conworth goes on to say is that he finds it hard to see on what basis the finding of intentional homelessness could properly be upheld. So he clearly does not consider that use of any of the guidance, such as the AHAS guidance, would be he can't see that would be a proper basis on which a finding of intentional homelessness would be upheld in the Samuels case. So all of that in my submission supports the idea that the position that we are in is that the applicable amounts, which are the figures set out in my skeleton argument, are guidance which an authority should have regard to, and the AHAS guidelines are not.
So your figures, is it paragraph 23 of your skeleton argument? Those are what you say the uncapped benefit levels would have been.
Yeah.
So there's something like £400 a month above the actual figures, is that it?
Yes.
And what are your figures? Where are they in time? Is that 2017 figures?
So, as I set this out, there was a benefit freeze from 2015 to 2018. The relevant period for the consideration here is the period from when the arrears started, which is the week of the 3rd of November 2015, until she was evicted, which is 7th of January 2018. And as it happens, throughout that period, there's a benefit freeze, which means we don't need to go through every year and say what they're uprated to.
And during that period, no rent was paid, or there isn't evidence as to what was and wasn't paid?
Well, there is a rent account which was in the original appeal bond under the county court.
Yeah.
I had a quick look through it while listening to your submissions. I could see at least one payment, but I know there may be more, because I was, as you can understand,
Little or no rent.
no, I would put it in this context. I don't know whether you've been able to read the narrative provided by my client's email submissions, which is in the second document in the supplementary bundle, but she sets out in a quite heartfelt way the way that the benefit cap applied to her, and she essentially says ruined her life. What is clear from that is that she was one of the early people to hear the benefit cap applied, and she was involved with officers of the legal welfare reform officers in council, and many discretionary housing payments were made over a period until the end of 2015. So it would appear to be the case that both the council, in making discretionary housing payments for a period of over 2 years, was doing that on the basis that it believed that the accommodation without that would not be affordable. I think that's the context in which this arises, and you may have noticed that the same comment was made in the original decision on Section 184 of the Housing Act, that the accommodation was said to be affordable without discretionary housing payments. It was only at the review stage, when the independent reviewer became involved, that the assertion started to be made that in fact this was a rent that Ms. Baptie could have paid.
All right.
Well, do you have a question for me? Or?
No, sorry.
Okay, thank you. Unless I can assist further in relation to the point about the welfare benefits in general, I just want to answer the issue about having regard to the welfare caps amounts in somewhat more detail. So we know that what was said in Samuels was that the tariffs of benefits were noted to be set at subsistence level. And that's there wasn't reference in the guidance to the cap. In my submission, that is unsurprising, because what the cap appears to be about is not actually an assessment of or guidance on affordability. It is rather a different decision, which is a decision about what Parliament has decided should be paid by way of benefits in certain circumstances. It's important to bear in mind here the fact that the benefit cap has exceptions, and one of the obvious exceptions is a person who is eligible for working tax credit because they, irrespective of what they earn, because they work for 16 hours. And in some of the documents there is reference to this. There are other exceptions, but the reason why I cite that as being a particularly relevant exception is one couldn't realistically say that 15 hours but had their benefit capped, had different needs in terms of affordability, somebody who managed to get to 16 hours and therefore didn't have their benefit capped. That's an unrealistic proposition and illustrates that the benefit cap is not aimed at that outcome. And as has been pointed out, it makes it makes no provision for any the number of persons in the household and their particular needs. I do want to address the paragraph 76 of Paley, insofar as that has comments to make about the relevance of the benefit cap. The point about the Paley decision, of course, is that it is a decision where affordability is being determined in the context of accommodation that somebody is going to, that the local authority itself is providing, and it is in that context where, in my submission, what is being said is that the local authority needs to, cannot simply ignore how little money it leaves somebody with in deciding what rent they're going to be required to pay in the accommodation they give them. And that is the way that we should understand it. That is because that makes sense because the homeless provisions, which make provision that somebody is homeless because intention homeless if the accommodation is unaffordable because it's not reasonable to continue to occupy that accommodation, that is part of the protection this is available for people who are subject to the benefit cap. So if one, as it were, says that you only have regard to benefit after the cap, you're essentially removing that protection from them.
I think the question is, to what extent should one have regard to uncapped or capped benefits? In the end, the decision maker is going to have to address what the actual receipt is, what the actual income is. The figure for capped or uncapped benefits, depending upon what view one takes of this argument, is only of significance, is it not, in terms of the light that it may or may not shine on what the reasonable expenses are.
More precisely, yeah.
Right. So the significance of the issue about the cap relates not to income, because income is income. That's a fact. The question is whether the assessment by the decision maker of reasonable expenses was a sustainable one or not.
No, the question at this point is whether they have regard, and I don't think they're now saying they did have regard to these benefit levels. We say they didn't. I entirely agree. The issue is should not the income stage at the reasonable living expenses. What is guidance?
The having regard is at the expenses stage.
Yeah, and our submission is they should have regard to the full amount and then work from there. So that's what they have regard to, and then they work from there. Samuels is very clear that, as is the revised guidance, that in considering essential needs, you take a starting point and you must then consider the particular circumstances of a household. It reminded me of the sort of situation with a Denton and White application where you have the first two stages and then you have the stage of considering all the circumstances of the case. And there might be a great similarity in that what the local authority needs to be open to do is take a starting point and then considering what particular circumstances apply to this family. Now that doesn't turn out to be so much the issue in this particular case.
But in a world of capped benefits, where one is in a case with capped benefits, why should Samuels be taken as ordaining that the starting point is uncapped benefits?
In my submission, because it is saying that is what is a guide to what is the subsistence level, and if you then go on to look at the way that is developed by Lord Commonwealth, he also refers as a reason why this is relevant to the duty under Section 11.2 of the Children Act 2004 to promote and safeguard the welfare of children, which obviously puts squarely in mind the need to have due regard to that, puts squarely in mind, you know, what are their needs, what are their benefit needs, and therefore the benefits for those, and that points to looking at the amounts set as being the benefit for those persons.
Yes.
Unless I can issue further in relation to the first issue of not having regard to benefits on the correct basis, I will move on to the issue of the reliance on the guidance. I have already taken you over what Lord Commonwealth has to say in the context in which he says it, and the impact that does or does not have on the decision in that case. I remind you that the call that he made at the end of paragraph 41 is that because of that shortage of objective guidance, the government should step in to address it, and there's no dispute that that is something which has not happened. But what we have in this case is the guidance as the guidance in its 2019 version, which is being considered by the local authority. You will have, I think, read in the judge's decision that he had both the 2017 version, which was what was considered in Samuels, and the 2019 version, and he made a comparison of the two. And if the those documents are in the supplementary bundle, and this is very obvious. The first version of the guidance appears at page 39 of the supplementary bundle.
You say that Samuels was looking at the 2017 version. Were they looking at the earlier version still? Because the decision in that case, as I pointed out earlier, was in December 2013. And this version, on its face, has had some review in the light of a further benefit cap. That's the 2016 revision.
I don't think there's any suggestion in the case that the consideration of the HHS guidance came from Samuel's actual decision. I think it's clear that this came in at the Supreme Court stage in the evidence of misneeded shelter, and that as that evidence was given before the hearing, the Samuel's case.
What was that evidence for? I was really a bit baffled about that. Now, here's a reviewing officer who hasn't looked at any objective source, so it's immaterial whether AHAS and all the rest of it are or are not objective materials because they weren't considered. So what is the intervener doing introducing all this evidence? What's the point of it?
Well, the point, as I understand it, was that the interveners, Shelter and CPAG, were very concerned about the two issues of a lack of consistency and that what guidance was around, and the three sources which you referred to, which the AHS is one of them, were inappropriate sources and should not be used. And what they sought to do was to put evidence about the lack of guidance, but in relation to the guidance, the lack of consistency, but in relation to the guidance that they identify about why they say it was not objective guidance and shouldn't be relied on.
It's one of the problems with interventions. The interveners tend to go off in policy directions that have little or nothing to do with the facts of the case. What were they asking the Supreme Court to do or say about guidance that wasn't considered by the decision maker? They were saying it was irrelevant and it was ignored.
But I think what they must have been concerned to do was to get some form of consideration of view out of the Supreme Court about this, and what they got was the statement at paragraph 41 from Lord Commonwealth, in which he dismisses it and clearly says that there should be something else done to provide objective guidance. I would suggest that looking at the guidance itself, one can readily see why it's not an appropriate source of objective guidance. I'm not talking here. I haven't criticised necessarily the source because it comes from a group of who are called HHS. That is not the concern about it. The concern about it is more the substance of it and its purpose, because the purpose of this is guidance which was created for a particular purpose, which was to say to housing applicants, not in the homelessness context, but people approaching local authorities, what it is specifically created to say to them, you should be paying this much, or you should do this. It is not, its methodology is clearly not intended to be some form of externally verified or objective research on actual living expenses. This is much more a kind of homemade type of exercise, and that is illustrated by looking at what is referred to as research that you've been shown by my lone friend. And it's also of note that there is no indication in any of this, the guidance, that any of the authors or anybody who's been involved with it has any actual expertise other than doing similar things that you or I or anybody else could do, going around the supermarket. So when you look at it in that sense, both the purpose that comes into existence and the methodology, it is not objective. It is driven to provide a particular outcome, and the whilst I wouldn't may not use the phraseology of the judge, it is right to say that what the approach taken in that guidance is an absolute stripped back, bare minimum approach to what somebody's expenses might be. So we're absolutely talking about somebody spending a lot of time going around to find the cheapest possible deals for things.
But the judge didn't have the benefit of Patel, which seems to completely cut across his assessment here. I mean, it's a problem for you, Patel, isn't it?
Well, yes, he didn't have the benefit of that. I think what is perhaps so what Nicholas Patton was answering in Patel was an argument that there is a difference between reasonable living expenses in the order and the code of guidance. And the question that still really leaves a question about what basic essentials are and how you approach those. And are basic essentials meaning that you have to go to a food bank, or what precisely do they mean? To give a very
well, I don't think food banks come into this case because it wasn't the decision made in this case that you've got to go to a food bank.
No, but my point is that there's room when you say what is needed for basic essentials.
Well, it's what are reasonable minimum expenses that meet your minimum reasonable needs is what the standard has been set at.
Well, yes. The question is whether the approach of the HHS guidance really is that.
But I mean, in the end, I mean, all of these submissions, which I understand why, because they feed into a decision, but in the end, we have to at some stage land at the decision, which is that the actual calculation that was done by the reviewer placed you just short of the line.
Yes.
Whereby your income would not meet your expenditure. And so in the end, whatever view one takes of the circumstantial matters and of guidance and so forth, it comes down to hard figures, doesn't it?
Yes.
For any decision maker.
Well, that is right. It does come down to hard figures, but it's a question of the approach to them. The use that's made of the AHS guidance in this case is for two very large items, the most important of which is the food and household items. My client, through her solicitors in the review submissions, and you'll recall that this issue arose in the Minder 2 letter, so it's set out in most detail in the response to that. She set out a figure of £960, and the AHAS is the basis on which that figure of £960 per month for food and household items
Yes.
is taken down to 728. So it's very material in this particular case.
You say food was one and household was another.
So food and household is one item.
Food, household.
And the other item is the, in which says that it was cut down, was the clothing, where she asked for a higher figure, but what was given.
Right, allow us remind us of the figures there.
The figure was £121.33. I would accept the review submission on that point is a little bit unclear in giving a figure. It says get more uniform, that she had to spend money on uniform, but it doesn't give, and that amounted to that she thought that she spent £1,360 per year on uniform, but it didn't go into precisely.
I'm sorry, are you able to say what was asked for and what was allowed?
So that's the difficulty about it. That if you look at page 37 of the supplementary bundle and the expenditure at paragraph 46.
Well, do we not find this in the review decision?
Well, I think if you want to compare it, I think if we look at, I can tell you what was allowed, but you probably want to see what was put forward.
Right, 37 in the supplementary bundle.
Okay, page 37.
Thank you.
And that gives us the figure in the grid of 121.33
Yes. So
calendar month.
right, that's right. That's why I said to you, it's difficult on this issue because the submissions were, which were back at page 34 at paragraph 29, were making a complaint that it was more, but I accepted a higher and referred to an amount, but they didn't actually put a higher amount in that box.
Sorry, I've just got lost. That the claim was for £121 a month. Is that what
What was
you're
allowed
saying?
and what was allowed. So that the clothing point is unclear. What is much clearer is the food and house.
Well, can we forget about clothing?
Yes.
Right. So there's a discrepancy of £232 in regard to food, which is the largest discrepancy.
Yeah.
And no doubt there are others. And the total discrepancy was what between claim and, I mean, you say here £1,901.
Yeah. The amount, the same comparative amount is £1,202.40. So it's £699.
Sorry, say that again.
The equivalent sum of reasonable living expenditure without rent in the review decision is 1202.40. So
Yes, and the difference, therefore, in round figures, £6.99.
yeah.
But to go back in relation to food and household, isn't it said in the review letter that the AHAS figures were taken rather than anything which had been suggested by your client's solicitors? Because it was said that the AHS figures were better? Because once they'd stripped out mortgage or whatever.
So no, I think you're referring to
I'm sorry if I've got that wrong.
page 127 and paragraph 23 of the review decision.
Paragraph 23. Yes.
But so there's reference there to Office of National Statistics figures which relate to an average household spending, but that's obviously relating to an entirely different size of household, which is very little relevant to Ms. Baptie's household. The question in my submission is whether the sum of £960 was reasonable and appropriately reduced by reference to these guidelines. And that, my submission, it was not, because in my submission, the guidance should not be relied on for as objective evidence what that expenditure would be.
Right, so this is the crux of this point is at the bottom of page 127, and at that bullet point spreading onto the top of 128. So there we have the figures of 960 and 728.
Yeah.
So what's the challenge to the AHAS figures?
So
£24 a week per person.
So the challenge is that the HHS guidance is not objective guidance of what the weekly food and household spending is.
But so it's a high-level challenge to that figure. It's not that any... I mean, the information available to the reviewer was what your client said that she spent, where two figures are given, the latter being the 960. Yes?
Yes.
So that's what it was said had been spent in a particular month.
Mm.
And the £24 a week per person figure which the AHAS guidance contained.
No, yes, and so you're right, it's high level.
So, I mean, there's no possible way in which that difference can be reconciled other than by reference to the issue of whether it was open to the reviewer to have regard to the AHAS guidance. And the high level complaint about that is the one made by Shelter to the Supreme Court. But that's as far as the trail goes. I mean, there's no more to be said about it.
Well, no, that's right. We say on the basis of what is objective in Samuels, and that guidance is not that. It should not have been used to reduce £200 from our budget, and therefore that alone would be enough to take us, as it were, under the line.
So, what was the reviewer supposed to do, other than what she did in that bullet point?
Well, in our submission, she had no good reason not to accept the amounts that we put forward.
Right, you say that it would have been irrational for her to do anything other than to accept your figure of 960.
If the only basis for disagreeing is the HAS guidelines, yes. And I don't want to oversimplify the matter, because of course there are some, whatever it is, 11 heads of expenditure that are gone through. Are there any others that are of even approaching the significance of the exercise that was carried out here, or does this epitomise what is happening? No, in relation to the AHAS, that is the case. There are then other complaints about it which don't relate to the AHAS.
So you're under AHS at the moment,
yeah,
and you're content to rest your case on the basis that you say it was that the bullet point assessment, bottom of 127, top of 128, is irrational.
Yeah.
you want to say anything more about AHAS?
No,
But it's helpful the way you explain it. In other words, it links in with that particular assessment.
yes. So we then have the non-AHAS complaints about the assessment of reasonable living expenses, and I mean, and this is really the answer to ground one of the council's grounds of appeal, which is interfering in a multifactorial assessment.
Yes.
Where so Nicholas Patton referred to misdirecting or failing to take relevant matters into account as being bases on which one could interfere. In our case,
Right. Well, before you give us the non-AHAS elements, what did the judge find about any of these apart from the mobile phone?
So the judge. The judge's finding in relation to this is what you have been referred to. Starting at paragraph 38, this is at page 76 of the full bundle.
Yes, well, that's an argument about the standard of review, isn't it? What the test is.
No, actually, he has accepted the sort of high-level submission, as it were, in relation to the HAS. He doesn't then go into the detail of doing it in this reason.
All right. So there's an absence in the judgment of any consideration of other elements than food and household. I mentioned the mobile phone, but could you just give us a list now of what you describe as being the objectionable, non-AHS elements?
So the objectionable elements which don't have anything to do with the use of AHAS.
Yeah.
Apart from the mobile phone, the very primary one is the number of people included in the assessment of food and household and clothing. So you refer to the bullet points at the bottom of page 127.
Yes.
And you'll note the last line of page 127 says, given that there's you and your 6 children, this would equate to £168 per week.
Yes. So you say it should have been 7.
So it should have been 7, and the difference that makes is I think it's £117. There's a similar point in relation to maybe £104. There's a similar point in relation to clothing, where the same thing was done to count somebody out, even though that person was present from the point where the arrears started rising in November 2015 through to September 2017.
Did the judge deal with that?
No,
I'll call that the seventh child.
yes.
Although I think it's the first in the
Yes. And the point about that is the amount of money involved. If you add them the two together, it's that in itself becomes is £121 a month. And
Say that again.
it's £121 per month.
That's the 7th child.
Yeah. For those 2 items.
Sorry, which are the 2 items? Sorry, it's clothing and
Food and household.
food, housing,
For the 7th child and clothing.
yeah.
So food and household is 232, you say. The discrepancy between 960 and 728.
Forgive me.
The 7th child point is worth 120.
And the 7th child is 121. Right?
The 7th child is 121.
Yes, right.
And these points were raised in my skeleton argument in front of the judge. So I fully accept there is no express reference to them, but my submission is that he must be taken to understood and accepted. They are points of
Right. The reviewer's response was that he was at university by the time you were evicted.
Yes, but clearly and that can't. So that doesn't explain. He left in September 2017. The eviction was January 2018. The period we're concerned with is November 2015 through to January 2018. So you can't hive off that one person just because they weren't there for the last 4 months. The affordability issue runs the whole way through that.
I'm just trying to get to the bottom of the procedural position here. The judge said nothing explicit about this.
No.
It's not the subject of an appeal, and I haven't detected it in your respondent's notice. So I'm just wondering whether, under what guise it's in front of us at all.
Well, I had considered that the respondent's notice in saying that there's no real prospects of finding the accommodation.
Oh, I see. It's in that.
Was a reference to that.
Yeah. Comes in.
I should have been more detailed, but it was precisely to these matters which I would submit that the judge should be understood to have had in mind.
It's the third point in your respondent's notice.
Yeah.
I understand. Thank you.
So the other point about these is a slightly more nuanced point. It's related to transport. The breakdown of expenditure which is allowed at pages 130 to 131 makes no allowance for any transport costs at all. There's reasoning dealing with it at pages 129 and over to page 130. This is a response to a claim that £20 per week was spent. If I can summarise the reasoning, it essentially seems to accept that there may have been some expenditure, but nothing is included.
And do you raise this again under your third ground on a general basis? Because I don't think it's not touched on by the judge again, is it?
No, it isn't. It was similarly. It was in the same part of my skeleton argument in which I argued that that on this basis their assessment was irrational, and in relation to so it's the same point that applies. It's not referred to expressly. I would submit that it was something that he ought to be taken to have in mind. And I know that the use of the he used the phrase that one must not nitpick, but a part illustrates the whole. And I suggest that that shows that he has in mind the warnings that judges in these cases are familiarly given about, but equally that the example given in relation to the mobile phone is being given as an example of a wider finding. But in relation to that point, I wanted to refer to the case of Paley and the way that the issue of affordability is dealt with in that case. It's at the final tab in the authority final tab 35, and this is paragraph 77, which is the third to last page. So the in Paley, it's a very acute description of how affordability can make a difference to somebody living on a very low budget. And then it goes on in the second to last line to say, a local authority is acting irrationally if, in order to make the figures work, they simply omit expenditure which on any view would be reasonable for a particular applicant who is in receipt of universal credit to incur in order to meet her her objectively reasonable responsibilities and liabilities, and the
I think though in Paley that was a situation in which there had been various schedules and those figures were left out of a following schedule. I think that might be correct. But also it's in relation to a property in Stoke when the lady had lived in London, and it's looking at transport being left out of the schedule in circumstances where a person could reasonably be expected to want to visit their relatives, even if they went by the cheapest bus service they could find.
Right, I'm grateful. I think I think you're saying that is you're referring to paragraph 73.
Aha.
And where this is found, and that's what you have summarised. Where one of the things which were omitted was transport costs to London from Stoke, is indeed one of the most memorable parts of that decision. But if you look at and I think that is over the pages as little 2. But actually, if you look at little 1, there is also a comment which is of relevance to this case about transport, and that is what I wish to refer the court to, because there's a very good description of why somebody might need to incur costs for transport, and where it refers to a 30-minute walk to school might be reasonable in one view. It might deprive Ms. Paley as a mother from choosing a school by reference to suitability of the school for her child. But then it says, even if one adopts the cutting one's cloth approach, it still ignores the fact that there may be perfectly sensible reasons why, from time to time, a child would need to get the bus to school. For example, if on occasion they had a great deal to carry, or in terrible weather, they were not soaked when they got to school, or on winter walking home in half an hour after school activities. And there were very young children in this household, and even if the young children could go free, there are perfectly reasonable reasons why, like that, why Ms. Baptie might need to incur expense of transporting going with them, and that I wish to rely on to support the argument that the exclusion of any transport costs for her was equally a reason why the decision should have been found to be unreasonable. That I think deals with the council's ground of 1, and then I just deal separately with the question of ground 4 and whether the judge was wrong to vary. And what I would say in relation to that is what the response what the council's scouting argument accepts here is that it says that £1,215 were available after the benefit cap income, whereas the after payment of rent found the expenditure is 1,202.40. So the difference there is about £13. The decision said so. If we just take the 7th child expenses, which there's no possible justification for excluding them, we just take those and add those back. We very clearly go beyond what was available. So with the £121 added on to the figures given by the review officer, you get to £1,253 of expenditure as against £1,215 available. And so it's just on that alone, it clearly becomes unaffordable. That it ignores any of the other things. It ignores the mobile phone, which I suppose also was unreasonable to exclude, and it ignores the there's 1323, and ignores the transport issue. But just looked at that way, you clearly get to the point where there isn't a basis on which, acting rationally, the authority could reach another outcome. They've clearly gone as far as they could to reach a low figure of reasonable expenditure. And once you add back in things which can't possibly be excluded, the sums simply don't add up. That is unsurprising, because this is a very particularly extreme case of the way that the benefit cap applies to reduce income from something. I would accept it might have been more extreme if there's a private sector rent, but as it is, that's my submission is why we get to a position where the decision to vary should be upheld. If you're not with me on that, then I would please ask for the decision to be varied to be a quashing order. I would ask the judge's decision to be varied to be a quashing order.
I was just looking at your skeleton argument before the judge, and I think the point that we've most recently been on is to be found at page 117 of the core bundle. Paragraph 55.
Yeah. Yes.
So, paragraph 55 of a 56-page skeleton argument, and 56 paragraph skeleton argument, in which you blend the AHAS issue at 1 with in sub 1 with the 6 children, the 7 child point. And the only echo of any of that detail that's found in the judgment is in relation to mobile phone expenditure, as it turned out. So I'm just making the point that this was not really centrally the point on which the appeal was run below. Your appeal was run on 5 grounds, most of which had to do with the high-level points about correctness of approach. And it's only really at this point, which is not even the whole of ground 5, because paragraphs 53 and 54 relate to the proper approach to the cap, that we get to arguments of the sort of detail that you now wish to fall back upon if all else fails. I just want your response to that.
I wouldn't say as it were falling back, because I would say that is why we had a clear case where we would get to this, because we get to a point when you look at this, it doesn't add up.
No, I understand that, but the stage at which you're making these points about individual budget items is really at the very end of the argument, and maybe because that's how it was presented, apart from a nod in the direction of the mobile phone, the judge doesn't even deal with them. And I'm just wondering whether that somehow reflects the nature of the appeal that was brought before him, which was brought at a high level, namely to pick up 2 main points. You have to look at allowances, not at capped benefit payments, and secondly, that you're not allowed to look at AHAS. So challenges to the, as it were, the 7th child point, and which, as you say there's no answer to, and there's other matters, travel costs and phones. We're not really the front and centre of your appeal, if one looks at the documents. We're looking at one paragraph in a commendably concise 16-page document.
The difficulty with this thing, one could go on for pages and pages about these kinds of reasonableness challenges. I don't think it makes any. It assists anybody hugely.
Not the slightest bit complaining about the pithy way in which you put it. But it's just simply when one sees the nature of the 5 grounds of appeal. This appears to have been put in as it were, something of a tailpiece.
Well, I mean, I don't think it can be said to be a tailpiece because I think it's clear that that's the basis on which one will be pushing for a variation. I mean, you know, if this was a simple matter of not taking into account guidance, then that would not in general point towards variation. So, I mean, the point, the point was argued, and in my submission, it's reasonably clear it's accepted, and when one looks at it against the background facts in which the case arises and asks the question, given what is there, acting rationally, could there be a different outcome? You get to the point where there can't be.
I understand. Anything else? Right. Now, is there anything else that you want to say at this stage, Mr. Marshall?
No.
All right. Thank you. Well, I think what we're going to do, if we may, is to take a break now, and we'll resume, if we may, at 2 o'clock.